Hey everybody, thanks for joining. On this episode of REI Partners, Richard talks about estate planning and asset protection. He goes into details about what estate is, principles of estate planning, and some ways that you can protect yourself as a real estate investor. Tons of great information. Hope you enjoy the show. Richard goes really deep into lots of subjects, and I believe everyone will benefit from it.
You may be a paper millionaire and not even realize it. You may also be exposed, though, if you don't have proper estate plan in place. And this makes you a target for those that would be unethical, okay? Everything you own is part of your estate, whether the property in question is of value or not. Value, of course, being the subjective term.
Welcome to the REI Partners Meetup. We're your hosts, Matt Morrow and Richard Clark. This is a place where knowledge is shared, friends collaborate, as we help each other to succeed in both our real estate and personal goals. We are a group of like-minded individuals from across the country who are here to help and support each other. Investors, realtors, entrepreneurs, and many others contribute to providing diverse and practical content for our events, especially our mentors who enjoy helping new and experienced investors in their journeys. Thanks for joining. We hope you enjoy the show and encourage you to bring others who may find value as we invest in our collective future.
Good evening, everyone. My name is Richard Clark, and we have on with us Matt Morrow, my partner. And this is the estate planning and asset protection presentation that I'm going to give today. Thank you all for joining. This is an important topic, I think, to all of us as investors and as individuals. We need to be prepared for whatever may happen as we build our businesses. And the idea behind this is just to give you a high level 30,000 foot view, if I can use some flying parlance here, nomenclature. So I'm going to admit Brian entered the waiting room again. Let me check that. Okay. As we get started here, we're going to talk a little bit about estate planning in general, and there'll be some questions and things that I'm going to present as questions that you need to ask yourself, because at the end of the day, you need to answer all of these questions and with regards to your estate planning decisions, and then that will determine what's going to be best for you. You're going to need to talk to people about what your estate plan is, and I'm going to give you the disclaimer here in a minute, but think about this. How many of you know the definition of an estate plan, and how many of you have a complete estate plan in place? Do you have those things right now? What do you hope to get from this course? It's going to depend upon what your specific needs are. So with that said, let me go through and give you the legal disclaimer first. Look, our company, REI Partners, its affiliates, its officers, and businesses are not registered investment, legal, or tax advisors, or brokers or dealers. All the information provided here in this presentation or on our websites is provided as information or for entertainment purposes only, and on an as is and as available basis. And you agree that such use of this information is entirely at your own risk. More importantly, the business gives no warranty or accepts no responsibility or liability for the accuracy or the completeness of the information and materials contained in this presentation or any affiliated websites. Under no circumstances will the business be held responsible or liable in any way or for any claims, damages, losses, expenses, costs, or liabilities whatsoever, including, without limitation, any direct or indirect damages for loss of profits, business interruption, or loss of information resulting or arising directly or indirectly from your use or inability to use this information, or from your reliance on the information and material as provided, even if the business has been advised of the possibility of such damages in advance. Any and all advice offered in this presentation and any collateral used in this presentation are strictly intended to be used for educational purposes only. Nothing within this document or associated collateral is to be considered advice or suggestion of any kind as to how you handle your estate. You should take independent financial or legal advice from a licensed practitioner connected with the concepts taught here, okay? You're gonna need to talk to your attorney, your financial advisor, your accountant, all those people for for information specific to your situation. You should independently research and verify anything that's presented here. And although best efforts are made to ensure that this information is presented as accurate, there may be occasion for errors, either in print or speaking. The business will not be liable for any errors or dissemination or offers any consolation for any errors known to have been presented in error, okay? And this document and all the associated materials and everything that I present to you today is property of REI Partners. All rights are reserved. No part or portion can be duplicated, communicated, transmitted, or otherwise disseminated in print or digitally without the express written consent of our companies, and which are listed here. So now that the legal disclaimers are out of the way, and I have to say that because it is important that we protect ourselves legally. That's the whole idea behind estate planning and asset protection as well, right? So what we're going to talk about, we're going to talk about what is an estate, what is estate planning, why is it important, asset protection, who is it for, where do you start, and then principles of estate planning. I'm going to speak briefly on PA. PA does have an inheritance law. I am not going to be speaking in terms of it from a legal perspective. I'm just going to mention it and mention some of the highlights of it. But you know, you'll look to your state. In your case, Caleb, you're in North Carolina. You'll look there to see what the specific inheritance laws or estate tax laws are for North Carolina and any other place that any of the other participants may be, okay? Questions an estate plan should answer. This is big because you need to answer questions decisively concerning your estate plan. Instruments and entities, I'll talk about the various documents and things that you'll need for an estate plan. I'll touch a little bit on tax strategies, and then what does it all cost? Of course, everything it all begins with it depends, okay? And then maybe some next steps. So I do have, as part of the collateral with this presentation, an estate planning questionnaire, which goes into some great detail of things you need to ask yourself and questions you need to answer. So you'll want to, I'll include that. We'll include that with the distribution so that you can maybe start the process by going through that and then asking yourself those questions. This is something that Matt and I have been talking about, maybe as offering as a workshop for people in connection with local attorney, tax advisors, accountants, financial planners, what have you, so that we might be able to offer this to people that really need some help but don't know where to start. Okay, but we haven't gotten to that point yet, but we may get there at some point. So what is an estate? Well, you know, an estate consists of everything that's owned by you at the time of your death, including any real estate that you have, bank accounts, stocks, and other securities, your life insurance policies. You may have several of those. Business interests. Any interest you have in a business is part of your estate. And personal property, such as your automobiles, jewelry, artwork, and any other personal effects that you might have that have intrinsic value. So when you think of an estate plan, you know, what's the first thing that come to mind? You think of a mansion on the acreage with gardens and a gated entry, and, you know, or money, lots of money, right? First thing you think of. Well, an estate can be really of any size. Most estates are larger than what you might expect. You know, the largest investment people make in their lives are in real estate. And some are fortunate enough to own more than one house, maybe two or three. In the case of us investors, we own multiple pieces of property, usually within entities, but nevertheless, we own them. I should say, we control them more than anything. You might be surprised to learn that your estate could be worth more than $1 million very easily when you take the real estate into account, along with your bonds and your stocks and your bank account and life insurance policies. You can quickly get to an estate that is worth more than $1 million. You may be a paper millionaire and not even realize it. You know, you may also be exposed, though, if you don't have proper estate plan in place, and this makes you a target for those that would be unethical, okay? Everything you own is part of your estate, whether the property in question is of value or not. Value, of course, being the subjective term. Estate planning is the process of anticipating and arranging during a person's life the management and disposal of that person's assets in the event the person becomes incapacitated or after death. That's what an estate plan is. In simple terms, it's having your ducks in a row before you kick the bucket. So there's little to nothing to fight over, and ensuring that your assets are handled the way that you want when you're gone. That's really what it's about. The planning includes the bequest of assets to heirs, and it may include minimizing gift, estate, generational skipping transfers, taxes. Estate planning includes planning for incapacity, though, as well as a process of reducing or eliminating uncertainties over the administration of a probate and maximizing the value of the estate by reducing taxes and other expenses. The ultimate goal, though, of estate planning can only be determined by the specific goals of you, as the estate owner, and may be as simple or as complex as you wish, or as your needs direct. Every estate plan is going to be custom. And sometimes guardians are often designated for minor children and beneficiaries. And in the case of incapacity, and this is assuming you don't have an estate plan. So estate planning means having a reasonable assurance of activities regarding your assets if you suddenly become unavailable. So think about that. If you have an accident or something that puts you out of pocket, well, who's going to manage your affairs until you get better or not? How many of you have heard of family members fighting over an estate, right? As soon as someone dies, the first thing happens is the sharks of the family come out. They're looking to see what they can get. It's unfortunate, but that's the reality of a lot of people's families. Is they have some unethical people that are going to be looking to get whatever money they can out of the estate of the decedent. It's something that's important to think about. So most attacks, though, to an estate come from within, not from without. When you're thinking about your estate plan, you got to think about who's in the family that's going to be the problem, as well as those in the family that you trust. Estate planning, what does it include? It includes you physically. It begins with you. What is your health like? And what would you want to happen if something happens to you? Who pays the bills? Who runs the business? Who feeds the cat? Who can you rely upon to handle your affairs while you're incapacitated? Who is handling the affairs of the ones caring for you? So if you choose someone that's going to be a trusted individual to handle your affairs, well, who's handling their affairs? And there's some other questions that we'll need to ask on that. Okay. Now I'll get to that a little bit later. But depending on the required activity level, your estate can begin to crumble in a matter of weeks if nothing is done to secure the finances and protect you from fiscal molestation. If you're in a long-term coma or you have a stroke and can no longer speak or write, you pass away, under what conditions do you want some action taken? What do you want to happen to the property, your business, everything? This is what estate planning includes, and it's very important to think about these characteristics. So why is estate planning important? Well, everyone has an appointment with death on their calendar. We all do. Planning for life includes planning for the unexpected. You don't know when your time has come up. Your assets could be subject to the disposition of the state all of a sudden, which is the probate process. And bills and expenses will continue if you're, say, not dead, but you're in the hospital and you're unable to participate. So are you sure things, though, would go as you expect? Do you have your funeral services funded? And do you know who will lead in laying you to rest? So if you don't die, but are in a car accident, you're unable to express your wishes for a period of time. What about the quality of life question? And when do you want the proverbial plug pulled, if that's the case? No estate plan means you are willing to trust whatever and whomever, including the state, to handle your affairs. Meanwhile, the bills and expenses will pile up and your estate financially bleeds to death. This is why estate planning is important. All right, so what is the whole reason for estate planning? Well, it's asset protection. The idea that we do all this, we make all this money, we work the business, we live our lives and better ourselves so that we can control what happens after we're gone. What about now, while we're living? Asset protection is a prerequisite and complementary to the estate planning paradigm. So the purpose of which is to keep our stuff from the grubby hands of government, right? Shark members among our family who can smell the blood of a dollar, and bottom feeders who would sell their mother to make a buck through civil litigation. Okay, asset protection is commensurate and inclusive to a sound estate plan. The key to good asset protection is to own nothing. That's really it. You don't want to own anything, but control everything. Being worth a lot of money personally is only feeds your ego, and that's not what's important. What's important is that you're able to control those assets and be able to do whatever you want with them, whether you are available or not. You know, before someone sues another person, an asset search is performed by the litigating attorney. What that means for you is that they basically look up and see, well, what is Matt worth? What is Caleb worth? Oh, gee, he's got like 20 houses he owns in his name. Oh, he's got an apartment building too, and he has a few businesses. Well, you know what? That's the cash register ringing in the eyes of that litigating attorney. Slip and fall on your property could cost you a couple $100,000 just to settle it. And that's really the idea. And the way tort laws are written in this country is such that anybody can sue anybody for any reason. There's been some suggestions, I believe it's in the legal community, where they talk about a good attorney can litigate or sue sue a piece of fruit or something. And remember, you have to defend yourself against that litigation. That costs money. But if an attorney does a asset search on you and finds nothing, well, he's going to go back to his client. He's going to say, well, you know what? This guy doesn't really own anything. There's nothing we can go after. So you know what? It's not worth it. That saves you a lot of time, a lot of headache, a lot of money. So what is important is that good asset protection means you can't easily be sued, and the appearance of wealth is not as important as the wealth itself. Get it? I mean, that's really what it's about. Control, not ownership, but control. Asset protection is performed through properly structured entities and various forms of legal instrumentation, which we'll get to. This is what asset protection is about, and some of the things that we're going to talk about, everything that we're going to talk about actually in this presentation, has to do with asset protection as well as estate planning, because that's what estate planning is all about, is protecting your assets. All right. Insurance alone, you say, well, I have insurance. I got life insurance. You know, insurance alone is not estate planning, nor is it asset protection. Insurance is nothing more than a guarantee of preserving value in case of catastrophic loss or accidental destruction. You know, the insurance value only adds value to the estate if it has cash value, or if its value translates into cash upon a transforming event like death or dismemberment or mental deficiency or something of that nature. Insurance payouts are not generally taxed, which is a good thing, but that's still money. And you treat insurance like cash, though, depending upon policy expectations for estate planning purposes. Insurance is something that we all have. The question is what happens if that insurance gets activated? What do we want to happen? In terms of tax strategies, you know, that's beyond the scope of this presentation, but remember, taxes for entities are similar to that of individuals or corporations. You want to make sure your accountant or financial advisor knows and can exploit the differences within the law, of course. You want to manage those deductions accordingly and use entities to defer or the tax liability where appropriate. You don't want to overcomplicate your situation. It's not illegal, though, to avoid taxes. In fact, it's only illegal to evade them. What we do every year when we file our taxes and we're looking at deductions to avoid paying more taxes than we have to, that is perfectly legal. It is illegal though to evade them, and there's a legal difference between those two. Work within the law and use it to your advantage. That's the key. That's the bottom line. Just a reminder though, a good relationship with your accountant, financial advisor, and attorney is important, and to consult regarding any tax matter. So who is estate planning for? Estate planning is for anyone who has assets of significant value to whom they wish to manage the distribution. Anyone with investments, stocks, bonds, real property, life insurance, personal collections, whatever. Homeowners need an estate plan. It's really, an estate plan is family management. It's frankly for everyone to some degree. Since no two estate plans are going to be the same, anyone with assets they wish to control should have something in the way of an estate plan. This would include a number of documents or instruments designed to make it clear what you want done if you can't talk. The term significant value I'm using here means a value that can be exchanged on the open market for cash, so liquidity. The value of assets is highly subjective, so particularly on personal assets like jewelry or personal collections. But assets such as real estate are subject to prevailing metrics in the market to determine value. So, they can be appraised. Securities and insurances have value based on their cash value. Estate planning is essentially family management, as I just said. Its purpose is to take care of the goldfish, that is the grandkids, right, while keeping every shark of the family fed, if not completely satiated. Where do you start? Well, talking to family can be difficult, but no one knows your family better than you. Family does not necessarily have to be people of blood relation. There are people in our lives that we're closer to than some of our blood relatives. There is nothing wrong with valuing relationships this way, as you've done it all your life. There's no better time, though, to be honest about your relationships than during the planning of your estate. So you want to talk to all the family, all relevant members, both good and bad, maybe clergy if you are religious, family doctor or primary care physician. It begins there. Anyone who has a legal interest in your estate needs to be addressed by you. So both good and bad, in your opinion. You may also want to talk to your clergy or religious affiliation if that's important to your plan. Maybe you want to take a portion of your estate to donate to your church or to some nonprofit. That's entirely up to you. Speaking with a family doctor is more about you knowing where you stand in terms of health and how much time you might have to get your plan in place. Your accountant needs to know how you want the family business or any monies handled. This should be as a private conversation as with your attorney. You may opt to make your accountant, if they are amenable, an executor or trustee to the financial aspects of your estate plan. If you want to do that, that's entirely up to you again. It's important to ensure, though, that you have at least one decision maker for each aspect of your plan. Your estate plan should not be, and I can't emphasize this enough, a democracy. You don't want to have multiple people involved in your estate plan. You want a small circle of trust, and for the people that are in that circle of trust to be intrinsically trusted by you, because they're going to be the ones handling things if you're not around. What you want to discuss with each of these groups is going to be different. Your questions should pertain to what if you weren't around, what you want to happen. So be careful that you control that conversation. Your goal is to get enough information to decide how you want things done and where that person may fit or not fit in the administration of your desired goals. Finally, storage of your estate plan is essentially keeping the documents in at least two places. Duplicate copies, multiple copies perhaps, but not too many. One with you and another with someone else, such as your attorney. Both copies should always be identical in every respect. If changes are made, and they will be over time, ensure that those changes are within hours of each other between copies. Guard your documents and keep them secure. Maintain version control over all your documentation, meaning you have language that invalidates all other documents of that type and use a referencing system between those documents. This is going to require, this is why it's important to talk to an attorney when you go through this process, is to make sure that version control is always there. Because if there is more than one version of a document floating around out there, well, that's an opportunity for someone to come in and say, hey, well, it says this on my copy. And someone else may have another copy of something, and they may have made copies to give to other people. You want to control that and make that sort of thing ill-advisable or unmanageable, okay? Or manageable, I should say. So that's where you start. Let's look at the principles of estate planning. Let's get into some of the meat of this. But before I get into this, I want to talk a little bit about the PA estate and inheritance tax law, which I'll talk about here in a moment. But the concepts and ideas behind estate plans involves knowing what the laws are in your state and modeling your plan around any tax landmines that might exist. There are some questions that every estate plan should answer, and knowing how to legally structure your estate will determine the effectiveness of your plan. Each legal document in an estate plan has a purpose and a precedence. Its powers and abilities are limited and well established. Knowing this will ensures that you don't end up with a plan that contains conflicts of interests, duties, or responsibilities. Pennsylvania has an inheritance tax. Any estate worth more than 50 grand, not including real property, must go through probate if the decedent has no estate plan in place. This is in PA I'm talking about. And there is an inheritance tax in PA. The tax is served not on the estate, but on the specific inheritances going out to each of the decedent's listed heirs. So you'll see there in the chart that, the tax rate, 0% for a spouse, inheritances to a parent from a child 21 or under, that's in the reverse direction. So for example, if you have a child who, say you had life insurance on and that child was accidentally killed and there was an insurance policy, well, that insurance, first of all, wouldn't be taxable. But if there was anything that child had that was of some significant value, and there's no inheritance tax with that value passing to the parent. 4.5% is for inheritances for children and for lineal heirs. Lineal heirs are basically people that are in your bloodline, both up and down to a common ancestor. 12% to inheritances for siblings, and then 15% for inheritances to anybody outside the family. That excludes any transfers to charitable organizations or any 501c3s, things like that. But there is no estate tax in PA, which is nice. The inheritance laws in PA are complex though, and they will require an attorney to navigate. And in the case of the workshop that we may end up setting up, I will have an attorney that will speak specifically to these types of questions. Non-probate inheritances, I won't spend any time on this, but just know that non-probate inheritances are living trust assets. These are things that are in entities or exist that are not subject to probate or inheritance taxes. So insurance policies, pay on death bank accounts, retirement accounts, things like insurance payouts, certain funds in a bank account for final expenses. Again, this is something that an attorney would speak on, and I would ask you to consult an attorney on non-probate inheritances if you have questions. So what is probate? Probate is basically the process of a decedent's estate, their assets going through the courts for summary disposition. That means that, I don't have an estate plan, therefore I'm going to trust that the state, in this case of PA, or in my case, Ohio, is going to handle my estate and the distribution thereof. It's a cold and impassive process with little regard for individual circumstance. It can be a long process because anyone who challenges or brings about and says, hey, you know what? Matt owed me money. Caleb owed me money. So you know what? The judge will allow that. And any claims filed against the estate are considered valid unless proven otherwise. Taxes, creditors, and municipal debts are satisfied first. There's no optimizations in the process. If you have personal property or real property that, we can get an appraisal for. Personal property, whatever, right? Spouses, children, grandchildren, etc., will receive the remaining distribution, if any, after the probate process. This is what you want to avoid with having an estate plan. It's probate. You don't want your stuff going through probate. And the idea behind having an estate plan, well, this will solve that problem. Questions an estate plan should answer. Here's some questions that you need to ask yourself. These questions need to be answered decisively. There should be no wiggle room as to the interpretation of facts. Who is your beneficial interest? Typically, this will be like your kids, grandkids. What assets go where and to whom? What assets get liquidated? How the proceeds are to be handled? How all your cash accounts, you got money in the bank, and your liquid assets, how are they going to be distributed? How taxes and expenses are to be paid, and from where? Any special conditions for the sale or distribution of an asset. Special conditions can be anything, like if a person accomplishes a certain thing, an award may be given, or if a person does not accomplish a certain thing or things, an award may be modified or rescinded. These special conditions are given in the provisions of an entity or a will, and there are distinct reasons why you would place them in one and not the other. But we'll talk more about that later. You can also preempt potential disputes that you predict might arise upon your passing. An example might be of a sibling for which you have no relationship, but would legally be entitled to a portion of your estate. You might make as a provision of your estate that there be conditions on whether that sibling receives a benefit or not, and the quality of any benefit. There's really an unlimited number of circumstances where this might apply, and with anybody. Finally, who does what? That's probably the most important thing, is who does what. I shouldn't say the most important, but you're going to have people involved. This requires you to think about those you trust a little versus those you intrinsically trust with your life. Do they have the ability to do what you would ask? Is the first question. Do they have the stamina to do it? Can they do it for as long as you need them to do it? Do they have the intellect for it? What about a neutral third party? You may want to use someone that's familiar with your financial or maybe your legal advisors to handle some aspect of your estate. You obviously trust them professionally, but does that trust extend to you personally? It's a very different kind of trust relationship. You know what? Look, I might trust you to work on my car, but I may not trust you to drive it. Does that make sense? So these are some of the questions that you definitely want to answer in terms of your estate plan. You have to answer these questions decisively. And again, be clear as to what you want people to do and who's going to do it. So, instruments and entities. Instruments used in an estate plan are, you will hear terms like instruments and entities as a means to help you understand the relationship between legal documents. Look, these terms have legal definitions, and this is not a lesson on giving any legal advice or attempting to teach you anything of a legal nature. That's not what this is for. This is only for the purposes of communicating a narrative describing estate planning concepts here. That's what I'm using it for, and principles as I personally understand them, okay? Nevertheless, instruments and entities are just another way of saying collectively legal documents. Instruments used in an estate plan are documents like your powers of attorney. They enable or empower certain abilities or duties by a person. Entities, though, are legal personas empowered with the ability of public discourse and with a degree of anonymity, because you're the puppet master behind the lines doing the things that need to be done. So an example of that would be like trusts. You use legal instruments to create legal entities. Entities are legal instruments constructed to behave and act like a real person. The idea behind them is rooted in basic contract law. So a registered corporation is an entity. A registered partnership is an entity. A trust is an entity. Entities are created by legal documentation that allow them to behave or to do things as if though they were a real person. Entities have all or most of the rights and privileges of a real person under the law. They can hold property, they can open up bank accounts, they can have credit, they can do all those things. Entities such as trusts allow you to assign a living or cognitive person to act in your stead when you are unable to participate. They can be made to extend your decision-making power beyond the grave to a point, and by proxy. By utilizing though an entity, your estate cannot be thrown into disarray just because of your death or a sudden inability to participate. Entities can allow you to live longer in a sense by maintaining the order in which you once lived, thus permitting you the dignity of an orderly and unburdened departure. These entities require maintenance and they have to be active insofar as their purpose requires. They need to have a legitimate and lawful reason to exist, which could be anything, right? You could set up an entity for the purposes of, say, managing the family finances, vague as it is, but it would be legitimate and lawful so long as the provisions within it are lawful. Entities can file tax returns, they can have credit, like I said before, and while they can't be jailed, they can be forced liquidated if mishandled, and you, as the puppet master, as I said, can go to jail if you do things that are illegal. Nevertheless, they are how estate plans are set up, and this is, and they can endure past your last heartbeat. So, what does basic estate plan documents consist of? Most of these documents in various forms are required for a complete estate plan package. They all enumerate certain abilities and powers to people trusted by you. Some are while you're still alive, and others come into play if there's a life-changing event. Some may be revocable, others irrevocable, and provisions can be made to trigger revocable into irrevocable, which comes into play with like trust. Some of these documents can be combined into a single agreement with multiple functions. For example, a living will can be combined with a medical POA to control the type of health care that is received if you become incapacitated. The last will and testament, which is optional, ideally though, should point to something else for the most important aspects of your estate. It's useful if the assets are below a certain amount, like around 50K by itself. But beyond that, you need to have the provisions of it really point to something like a trust. There's a living will and statutory living will with possible advanced directives for healthcare. There's durable powers of attorney for healthcare, general durable power of attorney for property and finances. There's mental health care powers of attorney, many different types of powers of attorney, and you can assign different people and give them different powers if that is what your plan requires. And one word on the power of attorney, though, a power of attorney is basically a written document in which one person, the principal, appoints another person to act as an agent on his or her behalf, thus conferring authority on the agent to perform certain acts or functions on behalf of the principal. That's what a power of attorney is. A durable power of attorney differs from a traditional power of attorney in that it continues the agency relationship beyond the incapacity of the principal. The two types of durable powers of attorney are immediate, and there's a springing power of attorney. The first type, the durable, takes effect as soon as it's executed. The second is intended to kind of spring into effect when a specific event occurs, such as, say, the disability of the principal. Other entities may be used in an estate plan, and depending on the complexity of your situation, it'll determine the best entities and instruments you need to satisfy your particular design goals. You might find that placing assets in silos to provide separation is important to sheltering other assets. This is particularly the case for real estate investments. All aspects of a properly built estate plan, though, package must interoperate seamlessly. And no more than 2 or 3 copies of your estate plan package, again, should be available. and they should only be provided to trusted sources. Some aspects of your plan may be disclosed to whomever you wish, but it is generally a good idea to keep the details of your entire estate plan confidential. One of the things you'll have, though, in your estate plan, besides some of these documents, is you'll have provisions that will tie them together or connect them in some way. And by having them connect in some way, gives it a more cohesive overall estate planning strategy. And that's what you're looking for. So what is the order of precedence? Well, estate planning is a package of legal documents that serve various purposes regarding your estate. The primary purpose of which is to protect you and your loved ones should you become temporarily or permanently unavailable. POAs and living wills work while you're alive and can be active or activated based on triggered events. It would be important that the living will and any abilities of a POA to not have provisions that could be in conflict. So you want to be careful of that. The living will can establish what your final desires are for healthcare, and the POA can enumerate the decision-making capability and possibly a timeline of potential activity. You and your assigned POA should be on the same page, paragraph, and letter as to what you expect and what they are expected to deliver. The last will and testament, if it exists, should be short and refer all decision-making authority to an entity of your creation, where there are trustees or officers purposed and entrusted to carrying out your wishes. If this is all you have, well, then it should be detailed and include an asset schedule. Everything, last will and testament, POAs, living will, all that is probate related. Everything above that dotted line, as you see in the slide here, are non-probate. Trusts or other entities is where the protection and control really begins. They control all assets. And it's important to know that you don't own a trust. A trust owns itself. Don't get in the habit of saying that you own a trust, because you don't own a trust. A trust is an entity. It's like saying you own another person. A trust is its own. It will have a tax ID if you get one, and it will participate as a real person. Be careful of language, because that language can also get you in trouble if you are not careful and you speak to the wrong person. But this is where the real control begins. And anything of significant value, it needs to be in the trust or some other entity. That's where your assets are going to be. You can be a trustee, preferably along with someone else. The beneficial interest of your estate, though, is not you necessarily, unless you're in a revocable trust, which may have already. But it's likely to be, though, your descendants or your beneficiaries. Because by separating that gives you some additional protection, because if someone wants to take something from you, they can't take it from your beneficiaries, can't take it from the people that your descendants, the people that you are building up your estate for in the first place. Just basic contract law. Understand that every estate plan is not going to necessarily look like this, but it will have some combination of these items or these elements.
You calling me?
No, but no questions, huh? So far, well, good. Well, that's basically the order of precedence, and you just think about this as you build your estate plan with your attorney of choice and with others that are in your trusted circle. Think about what you need to. The most important, I would say, out of all of these would be your POAs and your trusts. If I had to pick two out of all of them are important. But the trust is really where your assets are going to be maintained. And that's going to give you the durability after your incapacitation or death, that the control that you're going to need for your assets. And it is possible that you may end up having multiple trusts. You could have more than one. Depends on your situation entirely. So let's talk a little bit about some of these instruments. Okay, living wills combined with other documents like the POA are useful and should be a part of your overall package. But alone, a poorly written living will is useful to combine with your driver's license to determine how quickly your organs can be harvested. All right, everyone should have one. Most do not have, or they have one that hasn't been recently updated or isn't properly stored. How many people know someone like that, right? It is another useful tool though, and it is important in establishing who you trust with your medical care. Combine that with a medical POA. And I include in the documentation area PA living will and medical POA as an example of something that you could start with if you wanted to run it by your attorney. Then there's the last will and testament. Again, this is something that a lot of people say that they should have. If you don't have assets of significance, or you know of someone that don't have a lot of assets, they should at least have something like this. Gives them at least some idea of, it's not a primary estate planning instrument alone, but it's a probate instrument. But again, you know, it should pour over into something else if you have it. If you know someone that doesn't have this and needs it, well, then maybe you can help them get one or point them in the right direction. A pour over provision is important. Typically, you would take this if you're going to have this as part of your estate plan, and it should pour over into something else. It does have to meet certain legal criteria. You know, holographic testaments are not legal in all states. An holographic testament is a document that is written by hand, where it's written by hand of the testator, but there are rules behind what it must contain and how it is to be, you know, signed. You know, the idea of someone can scribble something on a napkin or whisper something in the ear of a loved one in their last breath, that won't pass legal scrutiny. But there's a lot of myths and legends out there about that sort of thing in terms of people trying to use that sort of thing as their last will or testament, as it were. Things that you shouldn't put into a last will and testament are things like funeral arrangements. You don't put that in a last will and testament. You don't put organ donation or financial designations. You leave all finances out of that. Life support decisions, that's what your living will is for. Assets in an LLC, again, that's a business. You want to handle that separately. Reasons why, a lot of people have put it into wills, reasons why they are making the decisions that they're making. You don't want to put that there because it leaves it subject to debate or argumentation. Life insurances and annuities and things like that, you don't want to have in a last will and testament. The pour over provision that I mentioned earlier is, you know, it can bridge the gap between assets that belong in, say, something like a trust, but have not yet been added to it. You know, it's somewhat of a catch-all provision to kind of ensure that anything not covered in the specific documentation of another legal document can be decided in another. Documents can be written to make this type of provision unnecessary, but, you know, it takes a competent attorney to address that question. The provision is simple, but it's very important in providing continuity across your documentation, managing any gaps in the flow of powers between documents. It doesn't have to only exist in things like a will, but it can be included in POAs and other documents as well. Any instrument can have a pour over provision, and a term meaning to say that anything requiring a decision not covered here has to be deferred to the authority within another document. In the case of like assets that may not have been added to a trust that you just acquired, and then all of a sudden you expire and that asset is up in the air. Pour over provision can help with that. The will is the first and probably most immediate step to resolve the potential dilemma before a court. If they see that in a will, it says to refer to the trust, well, then that solves the probate issue. Pretty much, not saying always, but that pretty much solves it. All right, so let's talk a little bit about trusts. Trusts are probably one of the oldest forms of contract known to man. They come in many different types. They serve any number of purposes. There is no specific type of trust per se. It's basically a contract. They're an important part, though, of the estate planning process. You don't own a trust. As I said before, it owns itself. Although all estate plans are custom, it could be reasonably asserted that a trust is almost always a necessary component of a comprehensive plan. It doesn't have to be, but commonly is a part of the picture. Trust can keep the contents of wills private to some degree. Trusts come in two general types. You have revocable or irrevocable, and they can be living or testamentary. A revocable trust is one where the provisions of the trust can be changed or revoked and new provisions added. Provisions can be altered or canceled depending on the grantor or the originator of the trust. During the life of the trust, income earned is distributed to the grantor, and only after death does property transfer to the beneficiaries of the trust. Revocable trusts allow beneficiaries to avoid probate court and guardianship or conservatorship proceedings, typically. A revocable trust does not exempt the requirement for necessarily a will. Revocable trusts offer little to no asset protections. This is important to note. This is like a living trust, for example. There's no asset protection really in a living trust because it's revocable. Revocable and living trusts are kind of one and the same. It's when it becomes irrevocable that it offers the asset protection that you're looking for. A living trust, also called an inter vivos trust, is a written document in which an individual's assets are provided as a trust for the individual's use and benefit during their lifetime. So while you're alive. A living and revocable trust is, though, helpful since it provides that flexibility and income to the living grantor, also called the truster. And provisions of the trust can be changed. And again, the estate will be transferred to the beneficiaries upon the truster's death. A provision can be made within a revocable trust that the trust become irrevocable upon the death of the grantor. Interesting. With different provisions coming into play based on that event. Again, that's something that you'll want to talk to an attorney about. Provisions to change a living trust into a irrevocable trust may have some traction or may have some validity in your particular plan. An irrevocable trust is a type of trust where its terms cannot be modified, amended, or terminated without the permission of the grantors, named beneficiary or beneficiaries. The grantor, having effectively transferred all ownership of assets into the trust, legally removes all of their rights of ownership to the assets and the trust. Irrevocable trusts provide some creditor and asset protection. A testamentary trust, also called a will trust, specifies how the assets of an individual are designated after the individual's death. Testamentary trusts are irrevocable. So depending on how an estate plan package is put together, different kinds of trusts may be used. There's life insurance trusts that can offer some unique and interesting asset protection and financial planning options as well. If you look closely at how life insurance is regulated and the cash options, you may find a personal bank in there somewhere. It comes down to how large your estate is and how much complexity you're willing to manage at the end of the day. You'll want, trusts allow you to control your wealth and protection of your assets, and they help you avoid probate. The major distinction is going to be irrevocable or irrevocable, and they have to be funded. This is important. Trusts must be funded to be considered valid. That means that you have to put money into them in some way. And trustees have to be chosen carefully. That's why they're called trusts, because you trust them or trust people with your life. There's no formal registration requirement of a trust with any government. Once the documentation is done, notarization of signatures, of course, but once that's done and you put it in place and you and your attorney has copies of it, you're good to go. What are some of the trust details? Who are the players? All right, well, you got your grantor, your settlor, and your trustor. This is the person who establishes the trust. That could be you. The trustee is the person who manages the assets in the trust. Generally, this is the same person that set it up, or it could be someone else. It's not always the grantor, settlor, or truster. The beneficiary is the person who receives the property from the trust. And a revocable trust, this is going to be you, but during your lifetime, it changes to your beneficiaries upon your death. Revocable or irrevocable, living or testamentary. And then there's provisions and clauses, which again are provided by your attorney. And then there's assets and funding. So these are the details in order to set up a trust. Some of the trust type examples. And these are just some examples. This is not in any way a full example of what trusts are available or anything. This is just a few examples of trusts that are available, and variations are really endless. You know, the important thing to remember is that of all the different kinds of trusts, each situation is going to be unique, and the provisions will reflect those qualities. You know, it's also important to not try to include every possible provision in a trust in an attempt to cover all possible conditions. You know, a well-written trust is the one that has clear provisions that can be easily understood and is readily complied with by the trustee and during the trust's existence. So it needs to be simple. Keep it simple. Lastly, when multiple trusts are in effect, though, while they can interoperate, it is important to not allow a provision in one trust to override the provisions of another if you have multiple trusts, such that it causes a disallowed action or activity under the law. These are just examples, you know, credit shelter trusts, insurance trusts, qualified terminable interest property trust. And I won't go through these different examples. These are just some examples that you'll want to be aware of. Hello there, Mr. Turner.
How you doing?
Pretty good.
Thank you for inviting me. I'm happy to see what trouble you guys are getting into.
Well, you're coming in on probably the latter third of the presentation, but glad to have you. Ken Turner is actually out in the Las Vegas, and he comes to us from the furthest. He's the furthest away of our participants thus far. So again, thanks, Ken, for joining us. I'll get back to it here. So these are some of the types of trust type examples. Again, there's any number of types of trusts. You name it, whatever you want, you give it a purpose, you assign the principal parties to that trust, and you get the signatures notarized after the provisions, of course, are created and and everything is done, and then you're ready to go. You would typically take a trust, you would go and to the IRS website, get a tax ID, and then that gives it visibility into the world of credit and taxes and all of that. And you treat that trust just like you would a person. You're just a person behind the scenes actually managing that particular trust purpose. Offshore versus domestic. I wanted to say something about this because, you know, a trust must operate under the jurisdiction of a government somewhere. And in the US, that would start with the state of jurisdiction. You know, some states are better than others, and there's no requirement for your trust to be set up under the jurisdiction of a state that you or your beneficiary resides. There's no requirement for that. You'll find that trusts, though, can be given different names, usually signifying their purpose. Just understand that this is largely meaningless. You know, a trust is just a contract with unique characteristics that allow it to fulfill a specific need or achieve a desired objective, and it has legal implications. It's not deceptive to name or market a trust type, as it helps in understanding the purpose of that particular trust, as I just showed you in the previous slide. A trust is subject to court orders, but they have to be written, they have to be within the jurisdiction of the court giving the order. In terms of offshore versus domestic trust, this is where things can get a little bit sticky. A trustee is subject to court orders, but they have to be within that jurisdiction of the court giving that order. So this is a problem if the trustee is not within a court's jurisdiction for civil proceedings. For example, if the trust gets sued for some reason. The attorney does an asset search, finds that you are the trustee of a particular trust and decides to sue that trust. And if one of the trustees just happens to not be in the country and you're required to get their approval to answer or proceed with any civil actions in some way. I'm not suggesting anything there. I'm just giving you a high-level example that talking about offshore versus domestic trust, just understand that from a court or legal perspective, talk to your attorney about this. There could be some advantages or disadvantages to that, is what I'm getting at. As legal costs go, it can get expensive in a hurry for a civil lawsuit to proceed against a trust, though, whose trustee is not in the country and or not a citizen of the U.S. Assets in an offshore trust are not within the reach of creditors, generally speaking. Offshore trusts are not a panacea, and they're not for everybody. So don't think that go and get an offshore trust or create an offshore trust and think that you're going to avoid or somehow not have to pay taxes or anything. That's not true. But they do require a bit more in the way of administration, and the people involved may be in a different time zone even. For irrevocable trust, though, this may not be a problem, as the term of the trust are already fixed and the duties of the trustee can be narrowly or more precisely defined. Domestic trusts, though, are generally sufficient for most and do not suffer as much from the suspicious leanings of, say, the agencies like the IRS and the federal government. Doing anything, though, offshore anymore is difficult and requires a competent attorney to navigate. So be careful with that. With FATCA and other laws governing U.S. citizens with offshore assets and bank accounts, there are reporting requirements that leave little to no room for non-reporting of those assets and some stiff penalties of non-compliance. So you just want to be careful with this, but you need to be aware of it because there is opportunity with using offshore trusts. Let's talk a little bit about durable powers of attorney. As I mentioned earlier, I defined what the power of attorney was earlier. It's a written document in which one person appoints another to act as their agent or on their behalf, thus conferring that authority. The durable POAs are an essential part of your estate planning. You need to have that because if you're incapacitated, POAs are not valid if you're dead. POAs die with the principal, but they are valuable if there is an incapacitation or if there is an inability of a person that, say, is suffering from something like Alzheimer's, for example. But they have to be completed while you're of sound mind. This allows you to assign trusted individuals with responsibility while you're alive, but you may not be able to express your wishes. Be sure that the POAs, though, are well written, especially if multiple people are assigned with various responsibilities, potentially overlapping duties. You don't want to have a POA where you have two people that have different ideas of what you would want performing functions. A POA functions could be financial or medical. You may want to assign one person to do the financial and one person to do medical. You want to limit the responsibility is the key. You want to avoid conflicts of function at all costs. Limit and clearly define the powers and avoid group decisions. Don't make your POAs subject to a democracy. Functions should be clearly defined and powers clearly enumerated. Breadth of responsibilities should be clearly delineated, and a provision referencing associated documents such as a living will, fully notated. The key is to avoid and eliminate areas of potential confusion. That's really where you want to avoid, and not areas of debate, but genuine areas of concern. In terms of other entities besides trusts, you have family limited partnerships. Those are valuable. There are another mechanism that can be used for asset protection. They're very good at that, in fact. They require a little bit more in the way of administration, but they definitely should be considered as a part of your estate planning and they do incorporate some tax strategies that are conducive to a solid estate planning scenario. An FLP is a type of arrangement in which family members pool money to, say, run a business project. Each family member buys units or shares of the business and can profit in proportion to the number of shares that he or she owns, as outlined in the partnership operating agreement. It's basically a partnership. An FLP is a business or holding company owned by two or more family members, in which each family member can buy shares in the venture for potential profit. There are two types of partners in an FLP. There's general partners and limited partners. General partner can own any percentage, but it's usually like 1% or the shares. And the limited partners, which are the beneficiaries, okay, this would be the kids, could get a larger share, like 99%. The reason for this is to minimize and defer tax liability, because you're only paying the taxes on the general partnership shares. FLPs are commonly set up, though, to preserve generational wealth within a family and allowing for tax-free transfers of assets, real estate, other wealth. They can be considered the long play, as they are immune to rules against perpetuities that affect things like trusts or other entities. They do require, as I said, a little bit more in the way of administration, and they're not immune to being pierced if a partner gets into trouble. So if that, say, limited partner happens to be a teenager who goes out and gets into an accident and kills somebody, well, then that limited partner's shares are subject to exposure as a result of that person owning that. There are some estate and gift tax advantages of a family limited partnership. FLPs and the tax laws that govern them are pretty complex, so professional consultation is definitely a necessity. There's non-government and non-profit organizations are another estate planning tool, combined with CRUTs, or charitable remainder unit trusts, that could make for some pretty interesting options. Diminishing returns, though, on complexity. As more entities are created, there's more administration, and again, it all depends on your unique situation, but you'll want to be careful that you don't overcomplicate things. Keep it simple. Again, corporations and for-profit entities are generally not a best fit for estate planning, but again, that doesn't mean that they never are a fit. In some cases, corporations or LLCs are going to be a part of your estate plan overall. So you'll want to be aware of that. Be careful of that. What does it all cost? This is almost a silly question. Estate plans are always customized, right? Everyone's estate plan is going to be different. Prices will vary based on that complexity. I'll tell you this, don't go to, I wouldn't recommend that you go to places like LegalZoom and set up your estate plan. You'll need to consult with a competent attorney that will be able to guide you on your specific situation. There's going to be an ongoing administrative costs because these are entities that actually have an existence in the world. But the real question here that you need to ask yourself is, well, what percentage of your estate's value would you be willing to spend to protect all of it? The best way to determine what estate planning means to you is to ask yourself that question. What is it worth to protect your assets? If it costs, say, for example, 1% of $1 million estate, that's 10 grand. Is it worth that to spend to protect all of that $1 million? I think the answer to that is pretty obvious. So estate planning is a life requirement. Summary here. If you care about your family, you need to have an estate plan. Estate plans are complete packages. They use entities who hold assets, giving you control of the assets without the burden of that ownership. Again, you want to control everything but own nothing. A poorly created estate plan is really as bad or worse than no estate plan, because it's just going to put you into probate and drive up your legal costs. But once set up, estate plans are pretty easy to generally maintain. It's not a lot you have to do. You just have to stay within the law and do your best to increase the value of that estate, which is what you're doing anyway. The best success plan for your estate is one that provides for you and your beneficiaries. And that's the presentation. Thank you all for giving me this opportunity to present to you the estate plan. We're going to open it up for questions. Any questions? Any questions on what we've talked about, what I've talked about?
I don't have any questions, but that's a lot of information. Thank you
Yeah, I know.
very much. A
Yeah,
lot
I
of
guess
time to put that together.
I did have a little bit of a question there. Matt and I talked about this a little bit, but when you say basically own nothing but control everything,
Yes.
I mean, can you dive into that a little bit more as far as, okay, what's safe? And I mean,
Oh, sure,
okay,
sure.
For example, equity partners.
Okay, sure. Here, when I say control everything but own nothing, if you own your house in your personal name, you own your car, say you got a couple of properties in your name, they're all in your name. They're in the name of, Caleb Wilson.
Mm-hmm.
Okay. If I'm an attorney and I do an asset on Caleb Wilson and I find that he's worth $10 million, and I got a client who feels they've been wronged by you, and I decide to sue you, I'm going to decide to sue you based on what I can find in terms of what you own. Now, how does Caleb hide his assets or make them less available to someone like me if I was that type of an attorney? Okay. Well, your home would not be owned by you, but by, say, an LLC. Your properties would all be owned by entities of some sort. An LLC, they could be in a trust for the benefit of your children. Then when I do that asset search under different circumstances, I find that, you know what? Caleb only owns like an old beat up hoopty car. That's all he's got in his name is an old Yugo that has, 100,000 miles on it. That's not worth me spending my time going after. Now do you get it? You see what I mean?
I do. Actually, everything I'm doing on the real estate end is in a LLC right now. And I guess one of the other things is I was informed by a client a couple of years ago that, okay, if I'm going to be doing investments, I guess, Matt, feel free to chip in. Anyone who's been doing this for a while, I guess they said, all right, separate it into individual LLCs.
Right. Sure.
I guess for every house that you own, basically, is that on? I mean, the attorney that I was talking to, they basically said, all right, you don't necessarily need to do that.
Well, you don't have to put every house into an LLC. You can have one LLC and have multiple houses in it. Now, that said, I will say that a badly structured LLC is like having nothing. Hmm. If you went to Legal Doom to create that LLC, or you went and pulled down a document to create that LLC, and you went and did all the things necessary to register that LLC with the state and all of that, and your member agreement or the provisions of that LLC are such that they don't really mean anything, or the business purpose or the purpose of that LLC is not clear, when a court looks at that, they're going to be like, this is nothing. It is you. It's like a single member LLC, for example, from an IRS perspective, is treated like you for tax purposes. If it's just you, you're the only member in the operating agreement, and it's just you. That doesn't really protect you. That gives you no asset protection. But if, say, you and Ken Turner had an LLC and you had properties in it, well, you're not the only one. Now it's different. Now it's more of a entity of its own, so to speak. Okay. So a couple of things there. One, single member LLC is generally not a good idea. You want to have a multi-member LLC, preferably with people that are not necessarily related to you, like not you and your spouse, for example. Again, you want to talk to an attorney about that, but that's generally the case, right? You want to take all your properties, you can put them under one entity. That makes it easier to manage. For example, with my capital investors, I create one LLC for all their properties, whatever the portfolio is going to be. I don't create one for each individual house. It's for all of their properties. So if they have, they give me $1 million, well, I'm going to put that under one LLC that we'll create based on our JV agreement, and then we'll go from there. I'm not going to do that for every property. So, yes, is that LLC exposed to some degree for in terms of the entire portfolio? Well, maybe, but will it be easier to protect? Yeah, because it's simple.
Okay. Yep. So
Right.
I mean, like having like an equity partner or something like that.
Right. And so personally, though, you want to have your living will, your DPOAs, you'll have your trusts, you'll have all that set up. You'll have your assets, maybe on your Schedule A for the trust, that you'll add everything that's of value to that. Again, you don't own the trust. Trust is just an entity. You're a trustee. Your beneficiaries, if it's a living trust, you are a beneficiary, for example. And you don't have to be the only beneficiary. You could have others. But one of the things that I mentioned earlier that I hope some of you caught was to talk to your attorney about making sure that your living trust as revocable, putting in triggers to make it irrevocable, because that's where your asset protection begins. That's where it starts. Does that help out, Caleb?
That did. Thank you.
All right. Any other thoughts? I know, Mr. Turner, you've definitely been involved with this out in your neck of the woods out there in Vegas. Any comments?
I think you're muted.
You're muted. Yeah, unmuting. There you go.
I do have a comment, and one of the things, especially when you're talking about entities, LLCs, corporations, and so forth, where they're cited, they are created, makes a difference as well. Some places like Nevada and Delaware have better protection with your entities than, say, Mississippi.
Right.
So
sure.
You may want to look at where you want your entities cited.
Right, exactly. Yeah, that's an important aspect to it. And certainly you want to make sure that all your ducks are in a row for how you create that entity or that business or company or what have you, and that you have it properly registered in the place where it's doing business. There's always layers to this as well. That's something I didn't really get into, but you can have layers of these things that comprise your estate planning and asset protection package. And those layers, and you create those layers for the purposes of creating complexity that no attorney is going to really want to go through to try to squeeze money out of you. Okay. So yeah, very good points. Thank you, Ken.
I also have another perspective also that I want to discuss, and talking about estate planning. I like to cite two famous people. One did something right and the other didn't do anything at all. Prince and Michael Jackson. Michael Jackson did his estate planning very well. There was no issues. Nobody argued. Prince died without a will or any estate planning, and they're still in court today, like 6-7 years later.
Right, right. And then I did
So-
mention that the probate process can take a lot of time. And like I said, a bad estate plan is like having none. And that's what happens. You trust basically the state to manage or distribute your assets when you're gone. And you don't want that. You don't want the state doing that. But yeah, thanks, Ken. That was good. What else what was the other expression? The other comment you had?
Well, as the probate goes, they're in no hurry to settle it.
No, right.
You know, the only thing that you hear from them is the cha-ching of the cash register, them draining cash out of the estate.
Yeah, with legal fees, right?
Yes, but I also wanted to comment that one of the best asset protection companies in the United States is here in Las Vegas, Anderson Business Advisors, and they specialize in real estate investing, setting up your real estate investments with the proper entities and how to use those entities for real estate investing. So they're worth looking at.
Okay, well, do us a favor and send us send me an email with some of that too, and then we'll definitely put that in the distribution on email.
Ken, can you repeat that again? The name?
Ken, say it again. Oh, I think he froze up. It looks like he's
Yeah, if you get the info from him, we could definitely keep it in the email.
yeah, definitely.
I don't know what's happening. I have limited resources on my computer, and the link just keeps disappearing and coming back.
Oh, yeah.
So yes, I will definitely send you that information. They had a webinar last month. It was a 7-hour webinar talking about asset protection for real estate. It was very informative. I watched it until I had to go somewhere.
Okay, all
What
right.
was the name of that in Nevada?
The name of the company is Anderson Business Advisors.
Yeah, thank you.
My sister Barbara and I have used them on a few occasions. Richard knows my sister.
Yep. I'm trying to get her as a CI.
Mhm.
Okay.
All right, well, thanks everybody. I do appreciate, we actually stopped a little bit early. We had this allocation for 2 hours and I kind of got through everything without a lot of copies, but it looks like we got it done. One quick plug for REI Partners I want to do, Matt, let me see if I can.
Yeah, you can't forget about our website.
Yeah, no, I got to share that. REI Partners. Can everybody see that?
Mhm.
Yep.
There you go. Well Through Real Estate. This is our website, reipartners.net. We will be doing some updates to it this weekend or over the next week or so. We're going to talk about, we have information on residential and commercial. We're also going to be talking about or be putting up on the website information specifically for capital investors looking to place their monies with us, and we will keep you attuned to what we end up doing. We do have the REI Meetup archives on there as well. So videos are posted to YouTube, and you can go to our website and see some of the past presentations that were done, both by guests as well as Matt and I. So quite a bit there that's already to look at, and we will be adding to this over time, and just keep coming back to it, and we will let you know when something new pops up from our mailing list.
Thanks, Rich, for the info. This has been awesome. You put a lot of work into that.
Thanks, Matt. I hope it was valuable to everybody. I mean, look, you know, like I said, I'm not an attorney. I've made several references to contacting an attorney to do some of this stuff. You know, I took my course from Jay Mitchell, and he's considered arguably the father of asset protection and estate planning. And it was a valuable course. I believe Mr. Turner also has taken it as well. So that's where most of my information comes from, is from the learning that I did over many years. And I just hope it was valuable to the people on the call, as well as anyone else looking at this video.
So Caleb, we normally have between 5 and 10 people on typically, and we've had as many as 20, 30 guys on for certain calls. So we're just trying to nail down a time and a date range that works well for everybody. But all the videos, as you saw, are uploaded to YouTube. Lots of historical stuff if you want to go back and take a look at it. Really good information.
Yeah, I suspect people will go back and look at this presentation a few more times, probably to get some of the stuff, because I did cover an awful lot, and
Not to digest in one sitting.
yeah. I had thought about doing this in 2 parts. One other thing I did want to show you, just real quick, and I think it's kind of important to the need here. Let me see if I can bring up. I was going to bring up the estate planning questionnaire. Here, I'll bring this up and show you what this looks like, if I can get it. No, you know what? I'm going to put that into the distribution email, because I think that it's a PDF that I have to bring up. So I will bring this up, or actually what I'll do is I'll just send it to everybody. We'll put that in the distribution, Matt. But the questionnaire is pretty intense and it's pretty thorough. So I'm somewhat kind of proud of it, but it does give you a good start to what you need to think about in terms of your estate plan.
Awesome, man. Thank you so much.
Thanks, guys.
See everybody.
Thank you.
Thank you.
Thanks, guys.
Bye.
See you, Brian.
Take care.
Caleb.
Apologize.
Bye.